Okay, thank you for coming this evening. We're going to get started. I'm Michael Ettinger from Ettinger Law Firm, and this is our Elder Law Estate Planning Workshop entitled Four Advantages of Using Trusts. And as you can see, this is the staff of Ettinger Law Firm. There I am, I'm Michael Ettinger, top middle. To my left on your screen, my lovely wife and law partner, Suzanne Ettinger, and a number of other lawyers and staff. Ettinger Law Firm's practice is limited to elder law estate planning, which is trusts and estates, wills and probate, estate tax savings, and Medicaid applications, Medicaid trusts. We have 12 offices in New York. In Nassau County, we're in Lake Success and Rockville Center. Suffolk, we have 3 offices, Islandia, Huntington, and Melville. Staten Island, 900 South Avenue. In Westchester, we're at 140 Grand Street in downtown White Plains. Rockland County, we're in New City, 345 North Main Street. Orange County, we're in the Crystal Run next to the police barracks there. A lot of people know where that is. Dutchess County, we have offices in Fishkill and in Rhinebeck, and in Albany right there on Wolf Road. Now, I understand that you can type in your questions as we go along, and I will take all the questions at the end, including a number of questions that were kindly sent in advance. So, let's get started. Well, fair enough. The first question is, what is elder law estate planning? And it breaks down into elder law, which you hear a lot about, but you're not quite sure what it is. Basically, it's for what we used to call seniors, but today the term seniors is a little out of date. We refer to our clients as older adults. So elder law addresses disability planning for older adults. Estate planning is what happens at death. And we like to say here at Ettinger Law Firm, we use trusts to create order out of chaos. And trusts avoid the pitfalls of wills by saving a lot of time and money in settling the estate because there's no court proceeding, avoiding legal guardianship if you become disabled. I'm going to explain the pitfalls of guardianship and how to avoid it. Keeping your assets in the bloodline instead of going to your in-laws and their families. How many people here listening today have had a case where the money went to an in-law and their family instead of the blood relatives? It's almost a cliche. It happens so often. Wife dies, husband gets remarried, wife number 2 gets everything, the kids get nothing. It's very common. So we avoid that by planning ahead to keep assets in the bloodline. And a big issue is protecting your home and life savings from the extraordinarily high costs of long-term care. In many places, over $20,000 a month in New York State now. And keeping control in your family and out of the court system. So if I had to boil it all down to one word, the word would be control. What we're doing here with these legal documents, taking back control from the courts and government, giving it back to you and your family. That's an overview. Now we're going to go into the 4 reasons why trusts are preferred over wills, or the 4 advantages of using trusts. The first of which is trusts protect you from guardianship proceedings if you become disabled. Wills don't. So let's look at that. A will takes effect at death, so it's exclusively what happens after you pass away. Well, here at Ettinger Law Firm, we have an expression. We say planning for disability is more important than planning for death, because planning for disability is for you. Planning for death is for someone else, obviously, so you come first. And the main issue with the will these days is there's no plan for what happens if you're sick, homebound, or disabled. It's not a plan for disability because it only takes effect at death. Well, a trust takes effect today while it's called a living trust, takes effect while you're living. And, you run it while you're healthy and capable. but the trust has provisions for who will take over if you become sick or disabled, and provisions for them to take care of you and manage your assets. And similar to the will, what happens after you pass away, but without the expense and delay of a probate. So let's talk about guardianship proceedings. They say eventually about half of us will have a period in our lifetime where we can't handle our legal and financial affairs. So what happens? Well, a lot of people become disabled. They don't have any plan. So the state has written a plan for them called guardianship proceedings. And what happens there is somebody, any interested party, a family member, Department of Social Services, doctor, lawyer, accountant for the family, financial advisor, somebody says your things are not quite right with you, and Adult Protective Services comes in, or a family member applies to have a legal guardian appointed. Now, you may have done a power of attorney and thought that protected you, but actually, a power of attorney doesn't stop a guardianship because the court can override your power of attorney and appoint someone else's guardian. So, power of attorney, very useful, but doesn't stop a guardianship. Why would the court override your power of attorney? Because a lot of these guardianship proceedings are started by hospitals and nursing facilities, and they're started by them because they want to ensure payment. And the court, realizing that the incapacitated person is in their care and custody and they have responsibility for them, is very sympathetic to these types of proceedings. So the facility gets appointed or their lawyers get appointed instead of the person you wanted because all you have is a power of attorney. And by law, when the judge appoints a legal guardian, the judge has to cancel the power of attorney. So it's right in the statute, the judge can cancel your power of attorney. So in this case, the court chooses who your legal guardian will be, and it may be and often is a complete stranger. So we're going to look at how to avoid that, but we're going to go into a little more into it. We want to stay out of guardianship proceedings because once you're in, it's notoriously hard to get out. You have to get back control. You have to go back to court and prove to the judge you're able to handle your affairs. It's almost an impossible burden because naturally, whatever got you into it makes it hard to get out of it. So these proceedings can be expensive, time-consuming, and stressful. They involve multiple court proceedings for family members. The incapacitated person's assets are going to pay for all of this, but it's very stressful because you don't know how long it's going to take. You don't know what the judge is going to do or who the judge is going to appoint. And again, it's very often somebody who the family has never met before. Another reason we want to avoid guardianship is because the legal guardian has limited options to protect your assets and nursing home costs. Now, one of the things we do, elder law attorneys do to protect assets of nursing homes, we put them into Medicaid trusts. But what if a client comes to us and they haven't set up anything and mom or dad has to go into a nursing home? We can still save about half the assets. Let's say mom is left and she has to go into a nursing home. She has about $500,000 in assets. We can save half those assets by gifting half the money. What's half of 500,000? 250,000. Even on a nursing home doorstep, we can gift half the money to the children as long as we spend the other half on mom's care. Well, typically we do that for our clients, but what if there's a legal guardian? Well, the legal guardian can't transfer 250,000 of mom's money to the kids because the legal guardian is guardian for the mother. So the legal guardian has to go to, first of all, the legal guardian may not even move to protect the assets because they're not theirs, they may not care. But let's say, and this happened to me, let's say you prevail on the legal guardian to make an application to the judge to transfer assets to protect it from the cost of mom's care. There's an article on it under in my website called Saving Assets on the Nursing Home Doorstep. It's under practice areas. But here, I got the legal guardian to agree to make an application to the judge. Let's save half of mom's money. She has to go into nursing home, but gifting it to the kids. So give 250,000 to the kids. As long as you spend the other 250,000 on mom, the kids get to keep the gift. Well, guess what? The judge turned down the application. The judge said, well, in my opinion, it's mom's money. It should be used on her care. And if there's anything left, that goes to the children. So guess what? We couldn't protect anything because the judge was in charge and the judge had a different value system from the family. So we don't want that to happen to us because conflicts often arise between what the family wants and what the guardian wants, or even what the judge wants. So who wants to be there? No one. So one of the prime reasons to set up a trust, because a revocable living trust avoids guardianship. Remember I said the will takes effect at death. We all know that. But unlike that, the trust takes effect while you're living, which is why it's called a living trust, and it stays in effect if and when you become disabled. I notice a few people joined us since I started. I believe there's a button where you can, at the bottom of your screen, where you can post a question. And if you do, I'm going to answer all the questions at the end. So we set up the trust in your name. We appoint you as the trustee or manager of the trust. So let's say your name is Mary Jones. We set up the Mary Jones Living Trust, and we retitle the assets in your name to Mary Jones, trustee of the Mary Jones Living Trust, dated whatever the date of the trust is. Now, the trust uses Mary's social security number. It doesn't file a tax return. It's the same as you. You have unlimited access. You can buy, sell, trade, spend. You can change who's in charge, change who you leave it to. It's completely flexible. It's the same as you, just a little bit of a different name. But the key here is we can name a backup trustee if you become disabled. How do we know you're disabled? Because the trust says your trustee has to get a letter from your treating physician stating you're unable to handle your legal and financial affairs. So the backup trustee gets the letter, and now we prepare a document saying mom or dad is disabled. Here's the doctor's letter. They can't handle their affairs, and under the terms of the trust, son Johnny is the trustee, and he'll be taking things over now, and please change the account name to Johnny, trustee of the Mom Trust. But here the persons you know and trust are in control instead of that legal guardian appointed by the state. The beauty of this, remember I said in guardianship, it's very hard to get back control, but with a trust, it's easy because it's your family. You take back control whenever you feel ready. But remember I said the court can cancel your power of attorney. Well, fortunately for us, the court can cancel your trust. The trust trumps the guardianship, which means what? You're going to get the people you choose in the event of disability. It's ironclad. You can have a first choice, a second choice, etc., in case the first person can't act or is not available or has an illness, who knows. But you're going to have a series of people, one after the other. So we know with our trust, we're going to avoid guardianship, and the judge can't appoint somebody else. A beautiful thing. You see, we're taking back control from the courts and government, giving back to you and your family. I would be remiss leaving this subject without talking a little bit about the power of attorney. Not all powers of attorney are created equal. In fact, the standard form used by the state of New York is actually too weak to do most of the things we need to do if you become disabled. So this elder law power of attorney, I call it prescription strength. And it works just like medicine. What happens if you only have over-the-counter medicine and you need prescription strength? You know what happens. It doesn't work. It's not strong enough. So this is prescription strength power of attorney, has 50 or 60 powers and on in the standard form. But the key is the power to transfer and protect assets in the event of disability. And for this, we use something called the unlimited gifting power. So the standard form power of attorney that most lawyers use allows you to make gifts up to $5,000 a year in mom or dad's name, $5,000 a year. Well, if mom has $500,000 and she's going to nursing home, and I can only give away $5,000 a year, what's going to happen? In 3 years, I've saved $15,000, and the rest of the money is gone. So remember I said, if you have $500,000, I could save half, $250,000. Well, you have to have my elder law power of attorney because this allows them to move any amount of money. So here they can gift that $250,000, which they can save now because they're able to move it. Under Medicaid, it's move it or lose it. And I can save half by gifting the 250,000 to the kids, as I said, as long as we spend the other 250,000 on mom. That's a little more complicated than that. It involves promissory notes and things, but the net effect is you get to save half. That's the important part. Technically, how it's done is a subject for another day. So I want my family members to have an elder law power of attorney. Whatever they can save, I want them to be able to move, and very often is hundreds of thousands or more. Get that from an elder law firm. So we like trust to avoid guardianship is number one. Number two, we like trust to avoid probate court proceedings on death. So there's that word control again. When you have a will, the court takes over control of the estate. So what is probate? It's a legal process to prove the will valid. You have the will, it was noted, supervised by a lawyer, witnessed by two disinterested parties, etc. But still, the will is not valid unless it's submitted to the court for probate, which really comes out of a Latin word meaning to prove a will. And you have to be able to prove to the court at the time of signing that will, your executor does, you are of sound mind, memory, and understanding. You are not under any fraud or undue influence. You are able to read, write, and converse in the English language. And so we have to submit that petition to the court, and the executor cannot act until approved by the judge. This can cause lengthy delays in getting access to money and other assets. Now, how long? It depends on the county, depends how they're busy. How busy they are. Suffolk and Nassau, not too bad. Upstate counties, not too bad. Brooklyn, terrible. Bronx, terrible. Staten Island, not so good. Manhattan, and not. Obviously the courts are much busier in New York City, so Queens is terrible. I'm sorry. Takes a long time. We want to avoid these court proceedings because in the meantime, you can't list the property for sale. You can't get access to the stocks, the bank accounts. You can't pay bills. Just very, very frustrating. So, and you're paying for this privilege because it can be 3% of an estate to probate on average. Figure that out, how much money that is. It's time consuming. And again, stressful. The stress is from not knowing how long it's going to take, what the result will going to be, when am I going to be able to get access to those assets. You just don't have control. And, everybody wants control over their affairs. So, and everybody wants to stay out of court if they can. So, allow me to digress for a moment, and I'll tell you how I became an estate planning lawyer. I was a litigation attorney for more than 10 years, from 1980 to 1991. And I was actually in my car. I was on a personal injury case, so chasing an ambulance, they say. And I heard on the radio that if you set up a trust, you don't have to go to court to settle. And an insurance man was doing a seminar. I picked up the mobile phone in my car. For those of you who remember, it was actually a phone, just like, where is that? Yeah, just like this one. It had a receiver. It was a big boxy thing in the car. I called and make an appointment. They were all excited because at that point, only wealthy people had mobile phones and lawyers. So they thought they had a high roller coming to their seminar, I guess. But I went to the seminar and I was shocked at what I learned. This was brand new. That if you set up a trust, you don't have to go to court to settle. And I thought, well, who doesn't want this? I mean, I just spent 11 years in court proceedings, including in many will contests. And I knew that this was for me because I wanted to keep my clients out of court, because when you go to court, you lose control. When you go to court, who's in charge? The judge, right? Now, when the judge says jump, your answer has to be what? How high? No, how high, Your Honor. Does the judge ever make a mistake? Of course. Does the judge always act in your best interests? Of course not. So who wants to be there? So I immediately actually stopped litigating. I went down to Florida, got trained with some very good estate planning lawyers. You can imagine why the best ones are in Florida. They had the most experience. Came back, I closed litigation practice, founded Ettinger Law Firm in 1991, 35 years ago, to keep people just like you out of the probate court, take back control, have your family in charge. Not only that, but wills are public records. So when you die with a will, anybody can go down to the courthouse, look up how much you had, who you left it to, where they live, how much they're getting. Not a good situation. People want privacy because people prey on unsuspecting heirs. So the trust, as you know, unless you've been living in a cave, you know that the trust avoids probate. But you have to get the assets into the trust to avoid probate. And I'm proud to say that Ettinger Law Firm, I think we do this better than anybody else. First of all, because we care to do it right, and we've been doing it longer than anybody else. So we're going to make sure that all the assets are in the trust. We actually do it for you. We don't give you the responsibility because we don't know if it's going to get done or you're going to run into roadblocks or you'll give up. So we do it for you. So some firms charge for that. We don't charge for it. We want to make sure that you get the benefit of what we set up. We want that Ettinger plan to work. So we're going to avoid probate proceedings entirely for trust assets. What doesn't go into the trust? IRA, 401k, 403b. First of all, they don't go through probate because, as you know, they have a designated beneficiary, but also, maybe unknown to many of you, IRA, 401k, 403b are exempt, protected from Medicaid, exempt. I'll get into that more later, but for now, the non-retirement accounts are all going to go into the trust. I'm going to save a lot of time. We're going to save a lot of aggravation, legal fees, court costs. Your family will be in control. Imagine this, somebody dies owning a home or a co-op or a condo. It can take a year to 2 years to be in a position to sell it. With a trust, it's a week or 2 weeks. The only thing you need is the death certificate. It comes within a couple of weeks and you're good to go. But this avoids court control of your estate. Nobody wants court control, especially in some of the slower jurisdictions. Upon death, a backup trustee can act immediately. Doesn't need to get appointed. This is a beautiful thing. Not only that, because it's not a public record, nobody can look up how much you had, who you left it to, who you left out. The trusts are private. Only people named in the trust have a right to see it. And it's much harder to contest. So if you're leaving somebody out, or you're leaving them less than they think they're entitled to, it's going to be very hard for them to contest a trust because in a will, remember, it's already in court. So it's not really that hard to challenge because it's in court. You just say, I don't agree, because you're a party to the contest. You're a party to the will probate, and it's very easy for you to contest. With a trust, it's very hard to contest because it's not in court. The trustee has already given out all the assets. You have to run after all the heirs individually. Well, lawyers don't like to take that on because the assets are already dissipated and it's hard to claw them back. And the judges give more respect to trusts and wills because they believe that if somebody did a trust, they're a little more sophisticated, probably knew what they were doing. And there's another reason. With a will, if somebody challenges a will, the lawyer for the challenging heir has a procedural advantage because if somebody challenges the will, their lawyer says, my client doesn't agree, nobody gets their share until the will contest is decided. So he has a procedural advantage. He can hold up the whole shebang. Now, the legitimate heirs, of course, they want their money. So they have an incentive to settle with the disgruntled or illegitimate heir because it may take them years to fight the will contest. So very often the person you left out or left less than they think they should get, they get it anyway because it's in a will. With a trust, there's no procedural advantage. The lawyer could say, I challenge, but it's not in court, so the trustee is free and has already, in most cases, distributed the assets and says, go run after all the people who have the assets. And again, much harder. People would have to sue their siblings, and it's very unlikely to succeed because the lawyer doesn't have the procedural advantage, and lawyers don't like to challenge trusts. We also have something called the multiple probate problem. Let's say you own a place here and a place in Florida, one of these pastel colored condos. You have to probate the will in every state where you own property. It's called the multiple probate problem. But you can deed your property from any of the 50 states into your New York trust and avoid these multiple probates. So trusts avoid court proceedings, not just in New York, but the other states you own properties. So reason number one was avoid guardianship. Reason number two was avoid probate, save the expense and delay and the stress. Reason number three, trust protect the inheritance you leave from your children's divorces, losses, and creditors. Keep your assets in the bloodline for your grandchildren. Wills don't. I touched on this in the beginning. How many people know a family or a friend, second wife got everything, the kids got nothing? It's almost a cliche. That doesn't happen here because for most of our clients, we're setting something up called the Inheritance Protection Trust, IPT. So instead of leaving it, so here's the issue, mom and dad are gone. They left, 500,000 to daughter. Unfortunately, daughter dies before her husband. It goes to him. He gets remarried. Wife number two ends up with the 500,000. Happens every day. What we prefer is you set up a trust for your son or daughter. We'll call your daughter Mary. So we set up the Mary Trust. We say, Mary, you're going to be in charge of the trust. You can spend whatever you want. You can buy, sell, trade, spend. You can spend the whole thing. We're not ruling from the grave. But the trust protects her if she gets divorced. The trust protects her if she gets sued. But it also says when she dies, whatever was in the trust goes to her children. What if she doesn't have children? Then it goes to her brothers and sisters, but it passes by blood instead of by marriage. You can even protect the beneficiary from themselves. A lot of people have children who can't handle money. Either they're a soft touch, they're not good at it, they don't have any sense of commerce or business. They might have a health issue, they might have a substance abuse issue, they might be controlled by their husband or wife. Lots of those around. So you can protect them by having somebody else in charge of their trust and use the money for their health, education, maintenance, or support. Health, it's called the HEMS standard, HEMS, HEMS, health, education, maintenance, or support. Okay, now here we have our family. So get me out of the way. Okay, so the inheritance on death is going to go by blood. So we're going to, there's Mary, okay, that's her husband, she dies, goes to the kids. Who's in charge of the money while they're small? One of Mary's brothers or sisters or whoever else you choose. Again, as I said, if she didn't have children to go back to her brothers and sisters, then niece and nephew stays in your family. Now, some people are actually quite fond of their son-in-laws or daughter-in-laws. Some people actually like them more than their own children, in my experience. But in any event, let's say you're very fond of Bobby here. You could say, if Mary dies before Bobby, and they're still married and cohabitating. They have to be living together because people could be married and not living separate and apart. So they're married, they're cohabitating. Unfortunately, she dies first. You could say, if you want to, most people don't, but some people do, give half to my grandkids on Mary's death, keep the other half in trust for Bobby, give him the income for life, and on his death, give the second half to grandkids. So he gets an income for life, but if he gets remarried, wife number two doesn't get it because it's in a trust, and he only gets the income. You could do that, or you could add it later. Essentially, what's happening here is your careful planning continues for decades. After you're gone, protects the inheritance you leave, your life savings. If the kids get divorced or sued, passed by blood instead of by marriage. This is a problem because, half of all marriages end in divorce. So you have to put in this protection. And then even if it's a good marriage, what if, a wife just happens to die first? Your son or daughter dies first. You don't know where the money's going to go. With the trust, you know where it's going to go. It's going to go to your grandchildren. Very popular, done tens of thousands of those trusts. Reason number 4, very popular reason, trusts protect your home and life savings from long-term care costs. Wills don't. Obviously, because the will takes effect at death. By the time you get to the will, very often there's nothing left because it all went to mom or dad's care. So for this, we use the MAPT, the famous Medicaid Asset Protection Trust. You're not breaking new ground here. I've been doing this trust for more than 35 years. So it's a wonderful tool. Oh, I hit the button twice, but it's okay. So we put your home and some of your money into the MAPT to qualify you for Medicaid benefits. This trust sets up 3 roadblocks that Medicaid simply can't break through. First of all, it's an irrevocable trust. Now, this is very confusing to people. A lot of people are afraid of the word irrevocable, and a lot of people have tremendous misconceptions about irrevocable trust. And the reason for that is because there's 100 different kinds. So they read something online, or their CPA or financial advisor tells them something that's 100% incorrect. You need an elder law attorney for this because we have a specific irrevocable trust in mind, the MAPT. Now, it's an irrevocable trust because you can't revoke it, but it can be revoked by agreement of all the parties. New York has a rule, it's an excellent rule, I would say. The irrevocable trust can be revoked on consent of all the interested parties. Who are all the interested parties? You and your adult children. If everybody signs, you're going to do it. I'll talk in a moment about what happens if somebody won't sign. But you have to name somebody else as the trustee. People usually use one or more of the adult children. But you cleverly reserve the right to change the trustee at any time. So they're in charge of the trust, but you're in charge of them. And that keeps them on the straight and narrow. You can fire them. You can also change who you leave it to. Even though it's an irrevocable trust, you reserve the right to change who you leave it to. Now, I can explain, how do you revoke it if one of them won't sign? Well, if one of them won't sign, I can take them out as trustee. I can take them out as a beneficiary. They're no longer a party. I don't need their signature. What does all this mean? It means you actually have control of this irrevocable trust. You can change who's in charge, you can change who you leave it to, and you can revoke it even if somebody doesn't agree. So I love the trust, but very few people know this, and very few people know how to do this type of trust with all these provisions and make it so flexible that you actually have your cake and eat it too. But I figured it out 35 years ago, the best way to do this, and I sleep well at night and never have a problem. If I need to undo it, I can do it. I think it's one of the greatest tools I've ever seen in the law because it's a classic. You actually have your cake and eat it too. Your assets are out of your name, they're protected. Anytime you change your mind, you take them back. Okay, so there's no downside. Okay, you're not going to get this information from your CPA. You're not going to get it from your family lawyer. You're not going to get it from a financial advisor because nobody knows all the ins and outs of a Medicaid Asset Protection Trust except a seasoned elder law attorney. The other thing is, at Ettinger Law Firm, we filed over 5,000 Medicaid applications. We're not guessing. We've been through it, doing it for 35 years. We know exactly what we're doing. And so a lot of people are getting their advice from a lawyer, a CPA, or financial advisor that never filed one Medicaid application. They don't even have a clue how it works. And they're advising. I just wrote an article on this. You may know this. I read a column in 13 newspapers. I wrote a column saying when it comes to elder law estate planning, there's more misinformation than information because everybody's giving you advice, your financial advisor, your CPA. And what I say is, actually, you think you're getting professional advice, but no, you're getting a personal advice coming out of a professional's mouth. It's not their field. So get your advice from the source. My website is trustlaw.com. You can download my new book. I've written 3 books just on this subject. It's in plain English. You can download, you can order it on Amazon. But at the website or in my book, you get distilled, correct information. It's out in the public domain. Every lawyer reads it. Nobody ever found a mistake in it. And it's actually used to train young lawyers these days. So you name one or more of the kids as trustee and you limit yourself to the income only. So that's interest on CDs, dividends on stocks. So let's look at who does this and why they do it. Well, middle class people have a lot of assets they're not going to spend. like your home, protect your home. But let's look at some of these other issues. It doesn't affect your lifestyle. You still get all your income. It doesn't affect your income. You get your Social Security, your IRA distributions, your pensions, your interest, your dividends. All income stays the same. A lot of people are living on that income. The trust makes sense for assets you're not going to spend, like your home. Put your home in the trust. The trust says you have the exclusive right to live there, use and enjoy the property. You keep your exemptions. Can you sell the home? Sure. Trust sells the house. You have the $500,000 exclusion from capital gains if you're a couple, $250,000 if you're single. The money's paid to the trust. Now the money's protected, and the trust, if you want, can buy a condo, still protected. You don't start that 5 years over again. Because the trust pays you out the income, you can put in the investments that you're just taking the income from, and you still get the income, and the principal will be protected. If you have a nest egg that you're not going to spend, why not put it in the trust and protect it for a family instead of leaving it there for somebody to take it away from you if you need care? So as I said, you have the exclusive right to use and enjoy your home under the trust, just like life rights, keep your property tax exemptions, etc. I said you have the right to, you have control over the trust by reserving the right to change the trustees at any time. And if you need care, either home care, there's no look back for home care. You get your assets in the trust, you can apply for home care immediately, but you have to need the care. And that means unable to perform any two or more of the activities of daily living, like washing, dressing, showering, etc. But Medicaid only gets the income. Your nest egg is protected for your children, and Lord knows they're going to need it because if you're like me or most of my clients, a lot of the children can't hope to accumulate the assets their parents did because it's a different world. So I said the trust can. How many times has somebody come in and said, "Well, my financial advisor said, yeah, irrevocable trust can't sell the house." Really? I mean, we've done it thousands of times. You can buy and sell trade stock. You put your portfolio into the trust, and your daughter is now or son or both are the trustees. What they do, if you like to still trade, they can sign what's called a third-party authorization with Morgan Stanley or Merrill or whoever you're with. And it says, they authorize you to trade on the account, and you run the account same as before. You can do it online or with the broker. We know there's a 5-year look back for facility care, possibly a new 2.5-year look back for home care. Hasn't passed yet. It's been on the agenda for a number of years now, but it gets voted down every year. So I don't know if it'll ever pass. Now, you put in your money. You can't take out principal because if you could get it, Medicaid could get it. But it's a way to get your money out. You can gift any amount tax-free to your son or daughter. Now, they can't give it back to you, but they can spend it on you. You need $50,000 for something, maybe take the whole family and your lawyer on a round-the-world cruise. That'd be very nice. So you tell your son or daughter, take $50,000 from my trust and pay the cruise. Why? Because when I have to apply for Medicaid, I have to show them what you put into the trust. Fortunately, I don't have to show them what the trust gave to somebody else. If you make a gift to your son or daughter from the trust, I don't have to show that to Medicaid. They never see it. They can't give it back to you because then it would show up in your bank account. That would scotch the whole thing. But if you gift it to them, they can do whatever they want with it. It's their money. So backdoor, you can get money out. IRAs, 401ks, 403b, teachers' retirement, TDA, all those. They're exempt from Medicaid, as I said earlier, except for the required minimum distribution. That's income that goes towards your care if you need it. But it pays to get started. Let's say somebody's, in questionable health or they're quite elderly. They don't know if they're going to make the 5 years. You don't have to make the 5 years. If you don't make 5 years, you only have to pay for the time that's left. So you set up the trust for mom or dad. Now they have to go into nursing home in 3 years. Well, then they have to pay for 2. You already got 3. So it pays to get started. It prorates according to time. So our conclusion here is estate planning with trust create order out of chaos, which is what we started with. And how does it do that? It avoids guardianship on disability, keeps control in the family, and gives you those asset protection options like saving half on the nursing home doorstep. It avoids probate on death, so you keep control. There's that word again. We like control. We like to give our clients control. I know about this because when I used to go to court, I had no control at all. I know what it's like to lose control. It's not a good feeling. Um, so we keep control in the family, save significant time and money in settling the estate, keeps your affairs private. Protects the inheritance you leave if the children get divorced or sued. I mean, how many kids have, I mean, every client who comes in has children who's divorced, and half the clients are divorced themselves. So protection from divorces, losses, and creditors passed by blood to your grandchildren instead of to in-laws and their families. Who doesn't want that? Extremely popular. As I say, I've done tens of thousands of these since '08. I invented this trust in '08. I've been using it ever since. And finally, we protect your home and life savings from long-term care costs, make you eligible for Medicaid for home care and nursing home care if and when you need it. That's a plan. So there's a copy of my new book, my 2025 book, Ettinger Law Firm's Guide to Protecting Your Future. Everything you ever need to know is in there. But our planning process begins with the seminar, warm you up a little bit. I'm going to invite you to a no-cost initial consultation. We'll give you a simple form to fill out so we have some information to give you advice on. We're going to give you a complimentary review of your existing plan, your will, trust, power of attorney, health proxy, whatever you have. And I will tell you exactly where the weaknesses are. I'm going to educate you and put you in a position where you're able to decide if you want to do something better and what the difference is. I say this, a few times, quite a few times a week, sometimes a few times a day. When you come into our office, we consider it our job to build your confidence. Everybody who comes in is at a low, almost everybody, is at a low level of confidence. They're not sure what it's about. They're not sure if they need it. They don't understand it. So we go slow. I'm going to explain it to you in plain English. I'm going to give you a copy of my book. I'm going to tell you which chapters apply to you. We're going to have a couple of meetings. We go nice and slow, and you'll never feel rushed or under any sort of pressure because we're not trying to sell you something. We're trying to educate you so that you sell yourself. You say, you know what, now that I understand it, this is a good thing. I want this. So we consider ours like an educational process. And you know what? We can just sit back and relax because once most people are educated, they say, well, that makes perfect sense. So let's go forward. So as I said, we'll give you a free copy of my book, Ettinger Law Firm's Guide to Protect Your Future, tell you which chapters apply to your situation. We'll also, at the first meeting, besides telling you what we think you should do and why, we'll tell you how much it'll cost, because everybody wants to know. This is how much it's going to cost. But we want you to come to a second free consultation to have your question. So you went home, you read the chapters, you might have watched my video on the website. There's a 37-minute video for advantages of using trust, very similar to it's actually the same as this, but you can watch it again if you like. So now you've read the book, you've reviewed it, you considered what we said in the first meeting. You come to the second meeting 2 to 3 weeks later. We answer any questions you have. We draft the estate plan together with you. What does that mean? Well, who do you want to make medical decisions? Your first choice, second choice. Who do you want to handle your legal and financial affairs? How do you want the estate distributed, all at once or over time? Are we treating everybody the same? Are we treating them different? Are there any special situations? What do other people do in this situation? Why? And we come up with a plan. And once we have a plan, we give you a detailed written proposal for the fee. Same fees we mentioned first time, but now it's in writing. This is what we're going to do, and this is there's the fee in writing. And then we say, what would you like to do? Well, a lot of people say it sounds good. Let's go ahead. And here's something unique to my firm. We don't have a retainer agreement. You don't sign anything. We give you a written proposal. We sign it. You don't sign it. And our proposal says we're going to do all these things based on your say-so. And when you come in, we're going to review all the documents, and after everything is signed, that you pay at the end. But unless and until you write us a check, you owe nothing to the firm. Why do we do that? Well, we do it because it puts you in control. There's that word again, control. So I was trained like every other estate planning lawyer in the country. When a client wants to go forward, you present your agreement, they sign it, they give you a check for half the fee, and you get going, and they pay the second half when you're done. But I analyzed that after a few years, and I realized that this is not the best thing for the client, because I just talked to you about taking back control with your trust and your power of attorney, avoiding probate, avoiding guardianship. Now, what happens when you go to the lawyer and you give him a retainer or her a retainer? You've lost control, right? Because what do you have? Nothing. All you have is a promise. You have to hope they perform. You have to hope you'll be satisfied, but you have nothing. You just have a promise. So actually, you've lost control. So I don't think it would be right for me to give a whole seminar on keeping control. And the first thing that happens comes to my office is I take control. So we keep you in control. And here's our theory. It's been very successful for Ettinger Law Firm. We feel that if we keep you in control right to the very end, obviously it's the best place for you to be. Now, if we're here to serve you, and that's the best place for you to be, it must be the best place for us to be. So to my knowledge, we're the only firm in the country that does that, but we're very, very happy with it because we only have happy, satisfied clients. And people like to be in charge. Sometimes people never come in to sign. We live in the real world. Well, okay, it happens. It's never going to make me change to take a retainer because that's the cost of doing business. It doesn't happen that often. And then, okay, wasn't meant to be. So you come in for your final meeting. We review the documents together, explain everything. You're comfortable, you sign. You need more time, we'll give you more time. We don't hold the pen in your hand and say, here, sign. It's very, very relaxed, very low key, very comfortable. But most people will sign, they feel very comfortable at that time because all their questions are answered. They have a very good understanding what they're doing and they're ready to go. So we review it, we sign the documents. You can pay by credit card, but these days there's a 3% charge. Nobody likes that. So most people pay by check. You can pay all at once, or you could do it over 3 monthly installments. Now, that's not the end of the process. It is in most firms, but not our firm, because in most firms, and even the New York State Bar seems to think that estate planning is a transaction. In fact, they advise lawyers after the plan is signed to send the client a letter thanking them, thank you for your patronage. This concludes our representation of you in this matter. Why? Because if you send them the letter, it starts the statute of limitations running. If you made a mistake after a few years, they can't sue you. That's how they train lawyers. Well, good for the lawyer, but obviously terrible for the client. So we don't do that. I think it's nonsense. And I'll tell you where it's coming from. Lawyers are more concerned with the 1 in 10,000 clients that are going to sue them than the 9,999 that aren't. We're just the opposite. We're not worried about somebody going to sue us. We're insured for that. We're not infallible. We could make a mistake, but we have insurance. I'm really much more concerned with the 9,999 that aren't going to sue us. So we don't take that advice from the bar. We don't think it's a transaction. We think it's a relationship. So we don't say goodbye. We say, hello, welcome to the firm. I trademarked the process back in 1990, so 35 or more years ago, where we keep people up to date of law changes through my weekly Ettinger Elder Alert. I write it myself. We also call you in for a free review every 3 years to see if there's any change in your health, your assets, your family, birth, death, marriage. I want the plan to work when you need it, not when you wrote it decades earlier, right? We don't charge for phone calls, emails, or questions. Why? Because we don't want people to be afraid to communicate or have a concern that is not answered because they're worried about getting a bill. It's not important to us. What's important to us is our client's peace of mind. So you paid us once, but you have us on retainer for the rest of your life. And it's not just you can call, email, but you can get the right answer, for heaven's sakes. Today it's very hard to get the right answer. You have to have somebody who knows what they're doing. But as I say, by using this program, your plan is never more than 3 years old, designed to work when you need it, not when you signed it, I hope many decades before. So I'm going to invite you to come in and see us. It'll be with myself or one of the 8 other lawyers at Ettinger Law Firm. They're all trained by me. We all use the same processes and systems. So you're going to get the same. But if it's one of the offices I'm working in, you can, if you want to see me, just say, I'd like to see Michael. My staff is trained. If you want to see me, they won't try to put you off on somebody else. We don't work that way. You're entitled to see whoever you want. So I much prefer to see you in person because there's magic that happens when people are in front of each other. You start to relate to each other. There's body language, facial expressions. If you can't get out, I'll do a Zoom. I'll even do a phone. It's not the best way to do it, not for me or you, but sometimes it's unavoidable. I don't know who can get around or who can't. Call us at the 800 number or visit. My website actually has 2 URLs. You can get, it's either trustlaw.com or ettingerplan.com. It's the same website. So you can do it right on the website, trustlaw.com, ettingerplan.com, or call the 800 number. Oh, okay. So let's see. Do we have any questions? Well, we have to stop the share. Stop share. There we go. Okay. Questions? Okay, we only have 33 questions, so let's get going. It says I have to sign in. Okay. Okay, Dennis, first, thanks for this and the information. So very welcome, Dennis. I also want to ask if an estate can protect timeshare ownership being a burden to children. Well, if they don't want the timeshare, you might just let it go into default and not make it part of the estate, and they'll eventually take it back. Anonymous, if the estate is less than 2 million, why do I need to file the final New York estate tax return, attach a federal copy of estate tax return when federal filing is not required? There's no New York estate tax return if your estate is under 2 million. I don't know where you got that idea. So you don't need a New York estate tax return. Paul, if I place our home into a trust, how does it affect the ability to borrow from a home equity line of credit? Well, I would say get the HELOC, home equity line of credit, before you put in the trust, and then you'll have it already. Karen asks, what about assets that have a beneficiary? Can these be taken by Medicaid? Absolutely. A beneficiary means who gets it when you die, but it's all available for your care because it's yours while you're living. So that avoids probate, but it doesn't protect from long-term care. Anonymous, what if you don't have a backup trustee? If you don't have anybody as a backup, you can use the lawyers here at Ettinger Law Firm. We'll do it for you. Anonymous, is there a maximum amount that you can gift at the nursing home door? There's no limit on it, but there's a practical limit of, let's say the nursing home is 200,000 a year, and you have $1 million. Well, you can save 500,000 by gifting it. But when you get over these numbers, you're going to have to give more and only leave enough for 5 years. There's no maximum. The point is you can give any amount. You can give up to 15 million tax-free these days. You just have to report the gift. Anonymous, does a living trust automatically include an elder law power of attorney? No, it's a separate document. It's completely separate, but it's part of the estate plan. Monroe asks, isn't there always some level of probate for the most simple will for personal property, not an irrevocable trust, and at what cost in today's dollars? Nobody probates for personal property. You only have to probate for things that have a title, like, but not even cars in New York, because if you have a car, the next of kin can go to motor vehicles with a death certificate, and they'll transfer the title to the car. But real estate, stocks and bonds, bank accounts, those have titles. Those will go into the trust and avoid probate. You don't have to probate for personal property. It passes by hand. Doesn't have a title, so there's no proceeding for it. Stephen, probate takes a long time. What is the procedure for the trust? Do we just bring a death certificate with the trust to the bank? Well, you come into us. There's a little bit of estate administration. We're going to prepare what's called an affidavit of trust saying, so-and-so was the trustee, so-and-so died, attached a death certificate on the terms of trust, such and such is the trustee, and here's a document whereby the new trustees accepted the trusteeship under this trust, and we put all the attachments, and we use many copies for as many banks as you need. And when you go in with that document, they will transfer the account because they have everything they need. Original death certificate, acceptance by the new trustee, the terms of the trust, etc. Armindo, for a married couple, the assets considered to be half each person? Well, no. Under Medicaid rules, Medicaid considers the combined assets of the spouses as all being available for the care of the ill spouse, regardless whose name they're in. Doesn't matter. We do have something called spousal refusal. It's on my website under practice areas. It's a different topic. Anonymous, my non-retirement accounts have beneficiaries. Does it mean they can be transferred to my children without probate? Absolutely correct, yes. But we might want inheritance protection trusts. So if we want to protect the assets, keep it in the blood, we're going to change the beneficiaries from your children to your children's trusts. Roberta, what would happen if you set up your accounts with your children and spouse and put your house in their names? Wouldn't that protect your assets and avoid probate at death or for long-term care? Well, if you, forget about your children and spouse, because your spouse is the same as you for Medicaid. If your spouse is on it, it's available for you. But do you want to really take your house and put in your kids' names? I can't tell you how many problems. If they get divorced, your in-laws are going to have a share. If they run into financial problems, medical problems, bankruptcy, and also they don't want their names on your house because it affects their mortgage rate on their house. What if they die and then it goes to their grandkids, their minors, the court-appointed guardian? No end of trouble. The point of all this, Roberta, is there's a right way to do things that doesn't lead to any problems, and there's a wrong way. And putting in your children's names is clearly the wrong way because there's just a host of issues and complexities there, none of which are good. Anonymous, my house is under an irrevocable trust and our financial accounts are under beneficiary designation. Do I need to do anything more? Well, your financial accounts are IRA, 401k, 403b, they're exempt. If they're not, we want to consider putting them in the trust because there's no protection that you have beneficiaries still all available for your care. Here's Roberta again. Are IRAs exempt from long-term care? Yes. And probate if beneficiary designated? Yes. Except, as I said earlier, the RMD, required minimum distribution, is available for your care. Are IRAs exempt from long-term care and probate? I just read that, sorry. Anonymous, what type of trust provides the best asset protection? Clearly, the Medicaid Asset Protection Trust. Alice, with a Y, says, what is the difference between revocable and irrevocable? Well, simply put, Alice, revocable trust, you're in charge, avoids probate, avoids guardianship, has no asset protection because you could take it out at any time. So say if you need care, Alice, take it out of your trust and give it to us. If you could get it, they could get it. With the irrevocable trust, one or more of your adult children are the trustees. The trust says you only get the income. So if you need care, they can't go after the assets and not in your name, and they can only get the income. Irrevocable trust also does all the other things, avoids probate, avoids guardianship. It also protects your assets, makes you eligible for home care or facility care. Anonymous, can the trustee of irrevocable trust file the final estate tax return? Usually in irrevocable trust, the assets are not enough to require an estate tax return. New York, the New York exemption is $7,160,000. People have that kind of money, don't need to set up the trust. They have enough income to pay for the care. So you're not going to need an estate tax return. What happens to MAPT if Medicaid is sunsetted? I don't think that'll happen in New York. So I don't see it as a possibility. Dolores, do I still need a will for make a trust? Yes. When we do a trust, we prepare something called a pour-over will, P-O-U-R, and that does two things. It cancels your earlier will because by law, a later will cancels an earlier will. But it also says in case there's some loose end that I overlooked, no beneficiary I didn't put in the trust, pour it into the trust after I'm gone because my wishes are written in the trust. Usually we don't have to use it, but we have to have it. Anonymous, how do you protect a co-owned house? A house where adult child's parent, their adult child, and her husband all contributed significant dollars to purchase a home the parents are living in. Title of house lists all four people. You won't need a trust for this because there's a Medicaid exemption. If you transfer, an exempt asset is a transfer to an adult child who's been living in the house for 2 years or more. So your adult child is living 2 years or more. As soon as you need Medicaid, you can deed your property to them. It's exempt immediately. That's a special rule under Medicaid. It's called the primary caregiver. They're deemed under the law to have taken care of you for the last couple of years, and therefore the house is exempt. You just have to make sure you have my elder law power of attorney, so if you can't do the transfer, they can do it for you. Anonymous. When you die, what happens to the MAPT? Under the terms, it pays out to the children. Do you need a lawyer? Well, sometimes, because if they have inheritance protection trust, we have to deed it from one trust to the other, or they want to sell and take the money, we have to do a closing. But there's not much. Armindo says, how do you determine which trust to create? How long does it take to put it in place? Well, it depends on your assets, your income, a whole host of, so do you have long-term care insurance? Is it sufficient? Are you young enough to get it? What's your plan for the future? Type of thing we have to talk about in the consultation. But, we have the first meeting. The second meeting is 2 or 3 weeks later. We decide to go forward. It's another 2 or 3 weeks. So, talking about maybe a 2-month process altogether. Anonymous says, how do Medicaid facilities different from non-Medicaid facilities? Almost all facilities take Medicaid, so they don't differ. Monroe, is there amount of assets such as multiple millions that would make an asset protection not beneficial? Yes, because Monroe, once your income exceeds $200,000 a year, the trust is, I don't need the trust to protect your assets because you have enough to pay for the nursing home out of your income. It's only for people who don't have enough income, under 200,000 that need the trust, because if you don't have enough income, they're going to go after your assets. But if you have enough income, they won't go after your assets because you're paying the bill. Armindo, do trusts protect foreign assets? Look, that I have to talk to you when I see you, because it depends where they are. It depends on the laws of that country. And sometimes we move those while you're living. Sometimes if it's Roman law, it automatically goes to your kids. We have to talk about that in person. Can I get a copy of the PowerPoint presentation? I believe it gets sent to you after we're done. Monroe, you can always call my office, they'll send it to you. It's also on my website, the same thing. So you can look at that. But, if you call my office, so it's 800-500-2525, extension 121, you can ask Allison to send you a copy of the PowerPoint. She'll be happy to do it. Monroe, or amount of income from pensions. Yeah, again, Monroe, if all the income from pensions, Social Security, RMDs, et cetera, if it's 200,000 or more, you won't need the Medicaid trust. Lorraine, if you set up a trust, you do not need a will. You need a pour-over will in case there's some kind of loose end, leases to the trust after you're gone, just in case. What is the basic cost for what you talked about, with or without the asset protection? A trust with a will, power of attorney, health proxy, single revocable trust is $6,000. A Medicaid trust for a couple between $7,500 and $8,500. These inheritance trusts I talked about are $1,500 for each child. It depends on it, but the value, when I set up an estate plan, the value always greatly exceeds the cost. If the value doesn't exceed the cost, I don't do it. I explain it to the client, the value is not here for you. Let's do something else simpler, or let's wait until the value is there. So, it costs, but it makes money or saves money. The value is greater than the cost. Karen, can your law firm only provide services for New York residents? Yes. What about potential customers in other states? I have a good colleague in Florida on the East Coast, a Boca area, Palm Beach Gardens, Boynton Beach. But after that, I refer people to the National Academy of Elder Law Attorneys. So you take down this website, naela.org, naela.org, National Academy Elder Law Attorneys. You can search for elder law attorneys by zip code. So look, you can scroll out 5 miles, 10 miles, look at the elder law attorneys, go to their websites, see who looks like a potential candidate, interview a couple of them, and invariably you like one more than the other. Here's Lorraine again. Can I get a copy? You will get a I think, I'm pretty sure you get the whole webinar after we're done. It automatically comes to you. Eugene, what office are you in? Well, that's a good question. I live on Long Island. I work in Lake Success a lot, Rockville Center. Once every couple of weeks, I go to Staten Island. And once a week, I go to White Plains. So you get me in Suffolk, Nassau, Westchester, or Staten Island. If you have a beneficiary in your bank account, is that protected from probate? Yes, that is. Anonymous, I have an autistic son, 13 years old, high function, but don't see him fully independent. Do I need a special needs trust? Yes, you're going to need a special needs trust because if he has any government benefits, we want to justify, we don't want to jeopardize those. Also, property outside the US depends on the jurisdiction. We'll talk about that. And are you, Anonymous says, are you familiar with internal laws regarding selling real estate, or do you know someone? I think probably meant to say international laws. Might be able to help you. Depends where the property is. What happens if you move out of New York? The trust is portable. It works wherever you take it. As long as it's valid in the state you set it up, it'll be valid anywhere. Anonymous, if you live in New York State now and set up a trust, later move to another state, the trust will not need to be redone now. Alice, if I'm in New York, everybody, same question, okay, it's still valid. Anonymous, number of attendees do not show up again. I don't know why. Is it my computer? I don't think it shows other people. We had 60 people listening in today. It doesn't show up on your end, it shows up on my end. Somebody wants to meet with Rockland. I don't go to Rockland. You have to come to White Plains. I have a very good lawyer, Michelle Berman, in Rockland. You can meet with her. Or if you want to meet with me, take the road. You'll do it midday, come to White Plains, no traffic, it's another half an hour. Okay, so that's that. A lot of questions were sent in. I'm going to take a quick look, and I want to make sure that I address them. Let's see. I think most of it was addressed. So if you have any other questions, please come in and see me. Here's a question from Jana. Pros and cons in placing primary residence in an irrevocable trust. There's no downside to placing your house in the irrevocable trust. Somebody says, if you don't qualify for Medicaid, why do you need an irrevocable trust? Well, who says you don't qualify for Medicaid? You can need to discuss that with me. I don't see why you wouldn't. Okay, I think I'm going to leave it at that. Thank you. Thank you for coming. Thank you for listening. Oh, there might be more questions. You never know. Got to check. Okay, good. So again, I really appreciate your attending. I enjoyed communicating and sharing my knowledge and information. Hope to see you in the office. And if you do, we'll be sure to take care of you. So thank you for coming. Have a good evening. And I'll say goodnight for now. Thank you.